Good morning, class. Today, I'm only going to be recording your tests, so make sure you access the speed building before the video and get your Q&A speed building. And so today we have 1 minute at 180 for practice before your lit, okay? Madam Forelady and ladies and gentlemen of the jury, by this indictment, which is the white sheet of paper that I hold in my hand, the state charges the defendants at the bar, Raywood Poole, who has on a green jacket seated at counsel's table, and Larry Welton, who has on a blue and red striped sweater seated at counsel's table with 2 counts. In count 1, they are charged with the offense of larceny or stealing in that it is alleged that on or about June 16, 1977, they did feloniously take and carry away the personal goods of Alton Smith and in the possession of Alton Smith of the value of more than $50 and described as follows: 1 Sears tractor lawnmower, and that these goods were taken with the intent to deprive the owner permanently of such goods. In count 2 of said indictment, the defendants are charged with the offense of receiving stolen goods in that it is alleged herein that these 2 defendants did on that same date receive certain personal goods of, and then you have on your 180 lit proper names, you have Mark Hill, and that's it, just Mark Hill. And let me just make sure I have my papers in order. You have July, make sure you capitalize it. Okay. And this is going to be then your 180 lit for 5 minutes, and it's for your mock, okay? The question presented on this appeal is whether the trial judge properly dismissed the criminal complaint against the defendant, Mark Hill, on the grounds that the state had denied him his right to a speedy trial. The record in this case shows that there was a 24-month delay from the time of the arraignment to the time of the trial. The defendant argues that the delay was due to the negligence of the prosecutor. He argues that because of the long delay, some of his witnesses were no longer in the state and some were not able to recall with clarity the incident that led to the charge. We conclude that the defendant was denied his legal right to a speedy trial, and we affirm the trial court's order dismissing the complaint. The charge against Mark Hill arose out of an incident that took place on June 2. On that date, a police officer tried to take the brother of Mark Hill into custody. The officer wanted to talk to him about a parole infraction. In the course of the officer's attempt to take the brother into custody, the officer went on Mark Hill's premises. Mark Hill tried to block the officer's pursuit of his brother, and in the course of the dispute, Mark Hill struck the officer. On June 9, the state filed a complaint. It charged Mark Hill with battery to a police officer. A warrant was issued, and upon Mark Hill's initial appearance in court, the judge released him on his own recognizance. This case, which commenced on June 9 by the filing of the complaint, was terminated by the trial court 2 years later, when the judge signed an order dismissing the charge. The record shows that at first the state acted promptly. Mark Hill has a right to a preliminary hearing within 20 days of June 9, but he waived that right, and on a motion by the state, the judge set the preliminary hearing for August 14. In the interim, Mark Hill's attorney withdrew from the case. On August 14, Mark Hill appeared with his new lawyer, who asked that the matter be adjourned. The judge then set the preliminary hearing for September 14. On that date, the court found that there was probable cause to believe that Mark Hill committed the crime and bound him over for trial. On October 1, Mark Hill appeared in court, entered a plea of not guilty, and waived his right to a jury trial. The judge informed the parties that he would not be able to hear the matter until January of the following year. With the consent of the parties, however, the judge ordered the clerk to assign the case to another judge so that the defendant could have a trial at an earlier date. The record shows that nothing was accomplished in this case until May of the following year, which was then approximately 2 years since the defendant entered a plea of not guilty and asked for a trial to the court. It was at this time that the prosecuting attorney discovered the file in his office, and it was this discovery that prompted him to file a motion requesting that the matter be placed on the trial calendar. On July 9, the defendant's attorney moved for a dismissal on the ground that the defendant had been denied his legal right to a speedy trial. The state acknowledged that a 2-year period was too long and that the mistake was brought about by an error in the clerk's office. The state admitted that the defendant was not at fault for the delay. At the motion hearing, the defendant stated that 15 neighbors had seen the alleged battery, but that now, when the case finally had been called for trial, he had been able to locate only 3 of those witnesses, and those 3 could not remember the details of the incident. The defendant testified that he had not spent any time in the county jail and had not made a demand for a speedy trial. He explained his failure to make such demands. He testified his former attorney had advised him that the matter had been disposed of. The defendant said he relied on what his former lawyer had told him. On the basis of all the testimony taken at the motion hearing, the judge found that Mark Hill's witnesses could not be located and that the memories of those who could be located were deficient. He found that the witnesses for the state kept good notes from which they could refresh their memories. The judge ruled that Mark Hill was exonerated from any duty to move for a speedy trial because he believed that the matter had been disposed of. The judge made specific findings of fact, and a perusal of the record and of the briefs on appeal shows that the facts on which he relied were undisputed. The general conclusion of the judge that the defendant was denied a speedy trial is a question of law which this court is obligated to resolve under the admitted facts of the case. It is undisputed in this case that the delay is chargeable to the clerk of court's office. The district attorney says that Mark Hill had engaged in no delaying tactics and that the delay was, and then we have 1 minute at 200 for jury charge. And this is going to be 200, 1 minute jury charge, okay? Your Honor, we have reached a verdict in this case, People versus Oliver Henry O'Rourke. We, the jury, in the above entitled action, find the allegation against the defendant, Oliver Henry O'Rourke, that in the commission and attempted commission of the offense as contained in count 1, that a principal in said offense was armed with a firearm, to wit, a handgun, said army not being an element of the above offense within the meaning of the Penal Code section 89577.3 true. This 15th day of April, 1994, Samuel M. Huffman, foreman. Ladies and gentlemen of the jury, this is your verdict, so say ye one, so say ye all. We, the jury, in the above entitled action, find the defendant, Oliver Henry O'Rourke, not guilty of the crime of attempted robbery in violation of section 1299.3 Penal Code of the State of New York, as charged in count 2 of the information. This 15th day of April, 1994, Samuel M. Huffman, foreman. Ladies and gentlemen of the jury, this is your verdict, so say ye one, so say ye all. We, the jury, in the above. And then we have on your 200 jury charge, Ms. Lewis and Los Angeles. And that's it. This is going to be then your 200 jury charge for your mock for 5 minutes, okay? I see court, capitalize it when you can replace judge in the sentence, the court. 200. Members of the jury, it is the duty of the court to conduct a trial in a manner that is fair and orderly. It is my duty to rule on questions of law arising in the course of the trial and to instruct you as to the law which applies to this case. It is your duty to accept the law as the court states it to you. As you listen to the instructions from the court, you should consider them as an entirety. You may not disregard one instruction or give more attention to one than another. And it is not your duty to question the wisdom of any rule of law that I state to you. It is your duty to determine the facts, as you jury members are the sole and exclusive judges of the facts in this case. You alone determine the weight and the effect and the value of the evidence. You alone also determine the credibility of the witnesses. Members of the jury, you should determine the facts without bias or prejudice and only from a fair and just consideration of the evidence. You will consider the evidence in the light of your own experience in life. During the trial, I will be ruling on motions made by counsel or by comments made by counsel. My actions during the trial are not to be taken by you, jury members, as any indication of the court's opinion as to how you should decide the issues of fact in this case. If the court has expressed any opinion as to the facts, you are not bound by that. What the verdict will be is your sole and exclusive duty, and it is not mine. I have no opinion whatsoever in this case, and I am impartial to both sides here. When you go into the jury room to deliberate, it is very important that when you first enter the room, you don't voice your opinion or announce how you stand. Remember that you are not advocates in this matter, but that you are judges. The final test of the quality of your duty lies in the verdict, which you will return to the courtroom, and not in the opinions that any one of you might have before agreeing on the final verdict. If you enter the jury room and state how you feel right away, then you may not want to change your opinion, even if you are shown that it is wrong. Bear in mind that you will make a contribution to the administration of justice if you can arrive at a fair and impartial verdict in this case. To that end, the court reminds you, ladies and gentlemen, that in your deliberations in the jury room, your purpose is not to support your own opinion, but to decide on the truth and to state it. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do that without violating your own good judgment. To each of you, I say that you must decide the case for yourself, but you will do so only after discussing it with all of your fellow jurors. Part of your duty is to make a decision as to the credibility of each of the witnesses. Remember that the things you may have read online or in the newspapers or heard on television before you were chosen to serve on this jury should have no bearing on your deliberations. This case has received a lot of public attention, and it has been said that the victim knew the defendant. In fact, ladies and gentlemen, it has been found that Miss Lewis and the defendant knew each other from when they both lived in Los Angeles. One of the witnesses stated that Miss Lewis and the defendant had been dating just before the night in question. It is for you to decide the impact that those facts should have on your deliberations here and who you believe and who you don't believe in this case. You are free to disbelieve all or part or none of what a witness says. In deciding whether or not to believe a witness, keep in mind that people may forget things. In fact, they often do with time. You, the jury, will be asked to decide if a conflict is simply a memory lapse or if it is a lie. Now, in this case, you have heard testimony from persons who have been described as expert in some field or another. A person is an expert when they have training and experience and knowledge in their field. You will weigh the testimony of an expert the same as you do any other witness, and you may choose to believe it or not. It is up to you, ladies and gentlemen. In this case, you may use only the testimony and the exhibits that are received in evidence. Some things are not evidence, and you may not use them in deciding what the facts are. An example of what I mean is that the statements of the lawyers made during the trial are not evidence. What a lawyer may or may not say in an opening statement or in a closing argument or at any other time is only to help you interpret the facts, and it is not evidence. It is their job to defend their client, but that doesn't mean that they or what they say in court is evidence of any kind. Members of the jury, if the facts as you recall them differ from the way the lawyers have stated them, it is your memory of the facts that controls here. The questions asked by the lawyers are not evidence, and neither are their objections. Again, it is their duty to their client to object if they feel that a question is improper under the law. And that is all. And we'll get ready for your Q&A. Michelle, there's 1 bar left of battery on this. You think it's enough?
I hope so.
I know. But, you know, maybe
Hopefully it'll last 5 minutes, because we don't have any batteries.
let me get the 1 minute.
Unless I take it out of this.
Oh, well, is that even working?
Mm-hmm. I should have changed it.
Is it just 1, Michelle, or is it 2? Oh, it's 1. Yeah, let's try it.
Okay.
It's worth it.
And then let's just switch it.
Yeah, you can just leave it in here. Oops. Yeah, that's a good idea.
Because I think these are, they're new, but I've been using it.
Yeah, good idea. See how many bars it gives me.
Yeah.
Okay, and so we have 1 minute at 2:25 Q&A. And this is, this must be low, the battery. But it's working. Listen, we better get that one.
The other one?
Yeah, because look, that doesn't even say battery low. You know what I mean? It's just, so
Yeah.
it's probably enough to get us through.
Okay.
At least this is just one.
I know.
That is always two. Yeah, because it doesn't say battery low on this, it just shows 1 bar, so.
Okay. Yeah, that one might
Yeah,
go up quicker. See, and it's still going green here.
I know, but it won't give us an indication
Mhm.
like this does. See, let me. I just turned it off. See, just 1 bar, so.
Okay.
Okay, this is gonna be then 1 minute, sorry you all, at 2:25 for warm up. From the blue moon until you left, how many times have you seen Bob Brad that you can roughly say?
I would say half a dozen anyway.
Okay, of those, how many times did you have conversations with him?
Just about every time we talked. Not saying that we're buddy-buddy or friends or nothing, but we never had nothing negative to say towards one another.
Approximately when was the last time you talked to him, if you remember?
Oh geez, I bet it has been 5 months at least. I would say 5 or 6 months at least.
How about at most? Can you put it in a range? If you can, recall.
I would say at most that it would be 5 or 6 months. Yes, it has to be about 5 or 6 months.
There is no question in your mind that Sam Bunsen, Lou Ways, Samson Part, and Carl Stork intentionally kicked you September 29, 1986 at the home of Bob Brad?
Yes, sir, though there is no question. There is no question in my mind whatsoever that they kicked me.
In one of the pleadings in this case, your attorney says that they maliciously kicked you. Would that be a proper characterization in your mind?
Yes, sir, it is. My injuries were pretty.
Okay, and so you have on your 225 Q&A for your mock, David Dorn Brown Chunk. Are you looking for this? It fell. Oh, no, it's in my bag. So
Oh, okay.
Court theory test and I
Okay.
didn't. David Dorn Brown Chunk, David Dorn Brown Chunk, David Dorn Yates, Mr. Yates, Sally Sue Yates, Kay Moon, Betty, and Kip. And I put Tess on me, okay. This is going to be then 225 Q&A number 1. And for your mock, and it starts in the middle, you all, for 5 minutes. Sir, I refer you to the answers to interrogatories which you signed. Do you recall doing those?
Yes, sir.
And perhaps your counsel has a copy of them that he can show to you. First interrogatory indicates that you also have been known as David Dorn Brown Chunk.
Right.
What does that mean? What is your name on your birth certificate?
I was adopted. You mean my natural birth?
Yes.
David Dorn Brown Chunk.
What does chunk mean?
A name my grandma gave me because they couldn't decide for about a week, so she put that on me.
Why couldn't they name you for about a week?
I don't know.
Just couldn't come up with a name?
No, I had to sleep in a dresser drawer too.
Why did you have to sleep in a dresser drawer?
I don't know. You would have to ask them all this stuff.
We won't get into that. So that's your natural name.
Right,
David Dorn Brown, Chunk.
right.
And that is your natural name.
Chunk is my nickname.
Okay, what is on your birth certificate?
David Dorn Brown, I believe.
Okay, now you are also known as David Dorn Yates.
Right.
When did you change your name to Yates?
In 1973, I believe it was.
Why?
My stepdad adopted me.
How old were you?
17.
You had been separated from your natural father?
Yes,
By death or divorce?
by choice.
Yours or his?
More or less mine.
And then your mother remarried,
Right,
and that was a Mr. Yates.
right,
And you took on his name.
right,
You are presently going under that name.
right.
Now, I see you have been married 3 times to 2 women.
One woman.
3 times to 1 woman.
That's right.
And is that the lady that is sitting out there?
That's right.
Still patiently?
Yes, she is as crazy as I am.
So you married the same woman, Sally Sue Yates, then 3 times.
Right.
You have never been married to anyone else?
No.
You were last married in 1985.
Yes.
Each of those marriages ended in divorce.
Sorry?
Each of those, the two prior marriages ended in divorce.
Yes.
And you have one child.
2.
2 children. Who is Kay Moon? Is that who your daughter Betty lives with?
Oh, yes. Okay. She is not living with her anymore.
Who was Kay Moon?
Just a friend of hers. They used to work together.
Where is Betty now?
She is a cook for a truck stop.
What is Kip doing now?
Being a kid.
Does he live with you?
Yes.
Is he in high school?
He is supposed to be.
But he isn't.
No.
What is he doing now?
Trying to find a job.
How old is he?
17. He will be 18 next month.
You have been receiving $1,140 per month in comp benefits.
Right.
Are you receiving those presently?
Yes.
But you are trying to settle that case?
Yes.
As I understand it, neither your injury nor the compensation have been affected at all by the incident of August 15. Is that correct?
Other than my rehab, no.
But that's not the reason you are not in rehab right now, is it?
Well, might have a good bearing on it because I was really unable to get around too good, you know.
Are you able to drive now?
Yes.
So you could do rehab now, couldn't you?
Yes, I could now.
Was there a period when you weren't able to drive?
Yes.
How long a period was that?
It was quite a while when I had both of my feet in casts anyways.
6 weeks?
Yes, at least.
Now, it is my understanding that you don't claim to have any permanent disability from this incident.
Not that I know of.
It is also my understanding you are not claiming any kind of a wage loss
No.
from this incident.
No, I didn't lose no wages.
Are you claiming that your future wages might be impaired as a result of this incident?
Oh, I don't really know how to answer that. You know, I just don't know.
Why not?
Well, I don't know how long this thing is going to last as far as being swelled up and what have you. I mean, they really are touchy.
Are you looking for a job now?
Yes, I'm looking for a maintenance job, you know.
Have you ever done maintenance work?
Can't be too much different than carpenter work.
So you feel like you know what the work is involved?
Yeah,
So I assume if you are looking for, or you feel like you can do it,
I feel like I could. I want to go back to work.
you are looking for work?
Yes,
Do you know why you are not finding a job?
yes.
Why?
Time of the year.
Just not a good time to hire on?
No, they just don't do it.
Was this at schools or hospitals?
Hospitals, hotels, schools.
When is a good time to find a maintenance job?
I think any time after the first of the year.
So you are hoping to get a job just after the first of the year,
Yes,
as soon as you settle your comp case.
I hope so.
Are you able to walk on uneven surfaces?
No, not so good.
But you can walk on them, just not as well as you would like.
Well, it is just like I say, it is really touchy. I mean, I can walk on a sidewalk fine, but say if there is a little twig or something on the sidewalk and I hit it wrong, I mean, it is pretty easy to turn an ankle.
Have you turned your ankle since August 15th?
Yes, I have.
Doing what?
Just walking. You know, just step on an uneven surface, not realize that it is there. You don't do it on purpose. It hurts too much to do it on purpose, you know,
Are you able to do your regular household duties?
pretty much.
Are you able to walk up and down stairs?
Slow.
Does your apartment have more than one story?
No, it is a home. It is a house.
Sorry, a home. Is there a basement or is it a ranch?
No, has a porch on the front and porch in the back, and there is, let's see, 4 treads and 5 risers.
So you are able to walk up and down those stairs?
Yes. I hang on, just going down, you know.
Are there any problems you currently are having strictly due to the inflammation of your left ankle?
Yes, as far as I know.
Were you able to? Okay, you all, so that concludes your mock. Make sure you access the speed building before this and have a wonderful weekend, and we'll reconvene next week with jury charge, you all. Have a great day.